There's some questions for John.
Yeah, so the divorce situation in the U.S. So now, unlike the original case study where the couple was outside of the U.S., if they're in the U.S., really is about in what state they're considered domicile resident. Again, each state has a slightly different definition. There's a tendency, though, to want to avoid to be seen as a divorce mill. So they wouldn't be extremely short periods of time, but they could be. It could be, a 6 to 8 week minimum period that you've been in that state before it attaches. Others may be more aggressive / conservative, depending upon how you're looking at it in claiming jurisdiction, and say, look, you got to be here for 6 months to a year before we would entertain that we have primary jurisdiction over this divorce matter. And then you'd also bring into play where the property is located, those same distinctions we've already spoken about, movable versus immovable property. Immovable more likely to have the U.S. jurisdiction, immovable, that is, movable property, maybe not, in a deference to a foreign judgment or order. And then same points that we've mentioned, they haven't changed in regard to the pre and post nuptial agreements and their effect on that divorce.
Okay, thank you. Yep, thank you, Zach. So, John, could the U.S. court order the Indonesian assets to be divided?
Yeah, so the typical, I would say, and I think Zach will speak a little bit more about divisions of property and variances of trust. The U.S. tends to shy away from this unless they're just left with no recourse. Sham transactions maybe, so if there was a transfer of that property, if it was movable property that was moved outside of the U.S. to Indonesia, if it wasn't immovable property, then they might try to invalidate the transaction itself. But ordering the specific division of something outside is not as likely, but it definitely is a possibility. And then whether the U.S. court order be recognized, again, I defer to Freddie on that.
Can you comment on that, Freddie? Would a U.S. court order be recognized in Indonesia?
Okay, basically all foreign court decision not recognized here. Parties have interest should relitigate or start from fresh the case in Indonesia court, and the decision from, let's say, U.S. court can be used as evidence, and expert opinion, let's say this involved is foreign law, should be provided as well to justify the argument. So that's the way if people want to enforce the foreign court judgment.
Okay, thank you. Move on to the next one. John, would the U.S. court seek to vary the terms of the Hong Kong Trust or divide the Cayman company shares?
Yeah, similar answer that I already touched on. I think the first kind of the main focus of the U.S. court would be a sham transaction or sham trust issue and just invalidate the entirety of the structure, not so much vary it or try to tweak around the edges. That common law concept exists within the U.S. system. It's just not as commonly used by the courts, definitely less so than the U.K., and I'm sure Zach can touch on that.
Yeah, I mean, from a Hong Kong perspective, there isn't any express firewall protections against the foreign matrimonial court order to vary or sort of declare the trust a sham, etc. Hong Kong, as well as, Singapore, in this case, Singapore doesn't have the protections, neither does Hong Kong. Both Singapore and Hong Kong have not adopted some of the more sort of robust protections that, let's say, jurisdictions like Gibraltar, Jersey, Guernsey, Cayman, BVI have adopted. So it is possible that the order seeking to vary the terms of the trust may be respected by a Singapore court, but it would really be as a matter of comity as to whether or not the court would do that. Certainly in other jurisdictions, I think the US is another one of these where there's no express firewall protections, but generally the courts will shy away from having foreign orders disrupting domestic trusts or domestic structures. That could be an approach adopted by the Singapore judiciary if it were to be a case. In Cayman Islands, they would again look at, because these are not money judgments, these are looking at transfers of assets. In many cases, they would look at comity as a basis to respect the foreign court. And certainly if we had an instance where, let's say Henry was deliberately transferring assets out of the US to frustrate a US family court from discharging its obligations to the marriage, the dissolution of the marriage, then generally sister courts will not look favorably on individuals sort of abusing jurisdictions to try and hide assets where there's a foreign family court trying to do the right thing by the parties. So it would be a matter of comity. There's no express firewall protections with respect to the Singapore Trust against a foreign judgment where it's dealing with a matrimonial order. So there's no express protections. The only protections that Singapore has deals with succession and inheritance claims.
Thanks, Zach.